I applied for and was lucky to get the job as a financial service division part-time judge. And so I started traveling from Bermuda to the Cayman Islands. A couple of years later, when I'd actually stepped down from my position in Bermuda, I became a full-time judge in the Cayman Islands, as I am now, but I continued to be a part-time judge in Bermuda. So I began traveling from the Cayman Islands to Bermuda to do work on a part-time basis there. So I have experience of being a traveling judge in two jurisdictions that are in fact quite similar in their basic legal framework.
That's terrific. Thank you so much. Yes, I mean, the similarities and differences between the different jurisdictions is a particular interest. And perhaps some of the students who are joining us will be also inspired by the public international law, private international law transitions in your career, which might speak to, I know some of my students appreciate that. Mr. Justice Reyes.
Thank you. I don't think I have anything much to add beyond what Alyssa has already summarized. Perhaps just 3 points based on the theme of this panel, which is traveling judges. So based on the theme of travel, as a domestic judge, as a judge of the Court of First Instance of Hong Kong, I didn't do much traveling. Domestic judges tend not to travel very much, but there were 3 travels, I think, that influenced me very much. One, the Chief Justice at the time sent me to New Zealand to take a judgment writing course to see if it would be appropriate to have a similar course in Hong Kong, and it changed my life. 2, the Chief Judge sent me to a CEDAR, Center for Effective Dispute Resolution course, at that time being held in Barcelona, or just outside Barcelona, in a place called Sitges, to learn more about mediation, to see how we could use it, what we learned in the course, to promote mediation in Hong Kong. And third, on a regular basis, every other year or so, the judiciaries, the commercial judges of Singapore, Hong Kong, and New South Wales have a regular conference in which they talk about handling, managing commercial cases, both in terms of substance and in terms of procedure. And all of those have, I think, shaped my life. The second point is something that Alyssa didn't mention. In terms of traveling, it was not really until I became representative of the Hague Conference on Private International Law in around about 2013, after I stepped down from the Hong Kong judiciary, that I traveled. My job as representative was to try to increase membership in the Hague Conference in Asia, to sell Hague Conventions in Asia, to promote Hague Conventions in Asia, and to listen to concerns relating to private international law, cross-border matters in Asia, and relay them to the Hague Conference's Permanent Bureau in the Netherlands. And I think one of my first visits was to Singapore to meet the, at that time, new Chief Justice Menon. In answer to your question, which is the last point I want to make, how did I become a judge of the Singapore International Commercial Court? I think possibly following the meeting I had with him a few years down the road, Chief Justice Menon called me up in Hong Kong and asked whether I would be interested in becoming a judge of the SICC.
I have a follow-up, which we can go out of order, whoever wants to take it, which is, in what ways do you think that commercial courts, or particularly commercial courts that focus on international commercial disputes, are suited or not well suited to having traveling judges on the bench?
Well, not all commercial courts have traveling judges. For instance, the Netherlands Commercial Court, I think all the judges are Dutch. But because of the geographical location and situation of the Netherlands, in fact, the outlook of the Netherlands is very international. first place. I think that international commercial courts are suitable for traveling judges because international commercial law is, as the name suggests, a system of international commercial dispute resolution, or part of a system of international commercial dispute resolution that is valid across borders, across boundaries. And so it's suitable for judges from all over the world to work towards the development, articulation of transnational commercial principles.
Yes, I would add that I think one particular sort of legal space that is very effective at incorporating traveling judges is what I would call the British common law world. Many jurisdictions, including Singapore and Hong Kong, and many of the present or former British territories, basically practice the law that was known as the English common law, but which was spread across the globe during the days of empire. And what that means is that you are able to draw on a common well of legal principles, especially when looking at sort of common law issues, contract and procedural issues, the law relating to injunctions. And in the smaller territories, such as the Cayman Islands and Bermuda, we have always, sort of going back to the 1800s, been dependent on judges coming in because there hasn't been enough local capacity. As time has gone on, the larger jurisdictions, such as Canada, Australia, New Zealand, Hong Kong, and Singapore, and the African countries have ramped up their local capacity to such an extent that there really isn't much of a need for traveling judges, except in the commercial area, because I think the commercial area is so international, and the significance of having a local judge dealing with an international commercial dispute is much less than the significance of having a local judge dealing with a constitutional issue or something like that.
I would add to what Justice Kawali has said that he finds advantage in the common law insofar as traveling judges are concerned, but I think there would be an equivalent in the civil law, and that would be Roman law, which was a sort of common law, jus communis, much before, long before the English common law became common to a number of jurisdictions. Professor Alan Watson, in his book, The Making of the Civil Law, asks why so many countries, not just in Europe, not just in continental Europe, but in Latin America, all over the world, have adopted a Roman law, especially in matters of civil and commercial matters. And I think it comes again from the idea that commercial law is as close as one can be to being neutral ideologically. So it can be adopted by many different jurisdictions, and you can adopt Roman law in that way for precisely it is ideologically neutral, or at least perceived to be ideologically neutral, and its common law can be adopted almost lock, stock, and barrel. It provides a convenient package that you can adopt, and you can have traveling judges to help interpret it.
Can I say that the concept of an international commercial court, when it is conceived, is usually to increase the reputation of the center, the city that is host to that international commercial court. The object is to increase that city's profile as an international business center. They want to attract international business in, and international businesses want to come to a place where they are not discriminated against or feel that they are at a disadvantage if they have to litigate their disputes in the local courts. Now, let's just take Dubai as an example. Dubai is a civil law jurisdiction in an Arabic-speaking country, but its economy has been booming for many years. And my understanding is that many people, many international businessmen would tell the people who run the UAE, we like doing business in your country, but we have two problems. One is that everything is in Arabic, and for those who are outside the Arab world, it's difficult for us to do transactions. So we need a place where we can do business and use a common language. Probably English is the most useful lingua franca to adopt. Second, if we have disputes, now we don't want to go to your local courts. Not that we disrespect the quality of justice in your courts, but it's not fair to us if we have to go and have a dispute and your local law says that only UAE nationals can be advocates and argue in the Dubai courts. And of course, it's in Arabic. So we can't have counsel of our choice and we don't understand what's going on. So that's not encouraging to us, and it's important for the security of our transactions to know that there is an effective legal system that we can make use of. So that was the foundation of the idea for creating the DIFC courts, or the DIFC Center, the Dubai International Financial Center. So it actually was a reverse of Hong Kong, but the parallel is there. One country, two systems. In fact, the first public lecture we had at the DIFC courts was when my predecessor, Sir Anthony Evans, invited the Chief Justice of Hong Kong to come and give, the inaugural lecture. And the theme was one country, two systems, to tell us Hong Kong's experience so that we could understand it and apply it. So you have an English-speaking center where the lingua franca in the DIFC is English. All public notices go out in both Arabic and English. And you have a court which is English language and based on common law. And of course, with foreign judges, and because English law is the foundation of local DIFC law, then the judges would have been Commonwealth judges. So that is the beginning of it. But within that court, we do a lot of international law, including local law, meaning UAE law, which of course is civil law based. So my knowledge of civil law has increased dramatically in the time that I've been in Dubai.
That is all so interesting, and I want to, of course, open up the floor if there's anything that anyone wants to respond to. But I will include also another question. So we had wanted, I'll combine two in light of time, right? So one question that I think you've spoken to already is about the similarities and differences between your home jurisdictions and the jurisdictions that you have found yourself as a judge on, and some of what you've said I think reflects a large similarity of jurisdictions, which facilitates this kind of traveling judge phenomenon. But I'm wondering if you would speak also to the any differences you've encountered and the extent to which you've either collaborated across borders for harmonization of law, or that you found yourself sort of in a comparative role, either as a judge or in another capacity, sort of using the experiences from multiple jurisdictions in the course of your judging. I don't know if anyone wants to take that on or respond to some of the interesting comments that have been already made.
Yes, I'll plunge in here. I mean, the connections between the different courts in the common law world are very strong. And if I think more narrowly at the similarities between Bermuda and the Cayman Islands, both jurisdictions have courts of appeal, which are heavily populated by retired English Court of Appeal judges, many of whom would, in their previous incarnations as Queen's Counsel, would have argued cases before the courts of the Cayman Islands or Bermuda. And the final appellate court for both Bermuda and the Cayman Islands is the Privy Council, which sits in London and is made up of the judges of the United Kingdom Supreme Court. And so there are many different jurisdictions, particularly in the Atlantic and Caribbean region, that all have the same highest appellate court. And so although technically the decisions of the Privy Council might be said to be only binding on the jurisdiction that an appeal judgment relates to, in fact, the reality is that a Privy Council judgment will be effectively binding on multiple jurisdictions. And so there is a constant citation of cases from different jurisdictions. The Cayman Islands has a very strong connection with Hong Kong because the majority of the companies listed on the one board of the Hong Kong Stock Exchange are held by holding companies in the Cayman Islands. And so much of the litigation in the Cayman Islands involves Hong Kong. You have parallel proceedings in insolvency for restructuring and winding up. And so the courts of the Cayman Islands have to coordinate proceedings with the courts in Hong Kong. So decisions that are made are constantly shared. Judges meet at conferences, insolvency conferences, and talk about best practices in terms of court-to-court communication. In fact, Singapore has been a big pioneer in establishing a judicial insolvency network. So a lot of collaboration goes on, and decisions are shared across many jurisdictions that have these sort of commercial connections.
Perhaps I just reinforce what Justice Gowally has said, because the first time we met was in an INSOL conference, I think in New Zealand. And there...
I think it must have been Australia, because I've never been to New Zealand.
Well, it was in Australia, and there I picked up some knowledge of cross-border insolvency that has been guiding me in the way I approach cross-border insolvency since that meeting. In terms of the question that Pamela has asked, even if you have a very similar legal system, take the system in Hong Kong and Singapore, they're very similar, especially in their approaches to commercial law. However, there are subtle differences between them that traveling judges, I think, have to adapt to. One difference I notice, immediately noticeable, is that Singapore counsel lawyers are much, much more polite than Hong Kong counsel. And Singapore judges are much, much more polite than Hong Kong judges. If I were to behave in the way that I behave in Hong Kong, I think there would be lots of criticism of that in Singapore, and so one has to adapt accordingly. Now, Michael and I are both, I think, members of the International Commercial Expert Committee of the China International Commercial Court, the CICC, and that is a wholly different legal system. China being a socialist country, and as well being within the civil law jurisdiction. So although I certainly have not had a case yet as a member of the ICEC, I've had to look into, just familiarize myself with the rules of the CICC and the procedures of the CICC, especially things such as interpretations by the Supreme People's Court and so on, things that are not, one doesn't normally encounter either in Hong Kong or in Singapore. So I think it's not simply a matter of judges, traveling judges, applying what they know from one jurisdiction to another, but also judges learning about the other jurisdiction and then moderating or modifying some of their views and their conduct in light of what they experience or encounter in a different or sometimes similar jurisdiction.
Just picking up on the last point that Anselmo made, people should note that although China has just recently established Chinese International Commercial Court, it cannot truly be an international commercial court in the way that we have been discussing so far. And that's for two reasons, both because of the Chinese Constitution. The Chinese Constitution says, first, all judges in Chinese courts have to be Chinese nationals. Second, the official language in the courts will be Mandarin. So that straight away cuts out any foreign participation as judges. And what Anselmo and I are on is a committee of international law experts. And what we are supposed to do is to advise the court if questions of foreign law come before the court. And those will be referred to the appropriate expert on the panel to advise. So far, Anselmo has had no cases, as he said. I have had no referrals, although I'm much more recent appointment. And I have yet to meet any of our colleagues on the panel who have direct experience of being asked to give advice. I tried to look up the reports of the Chinese International Commercial Court, and I went through about half a dozen of them, which were referred to me, which I could get an English translation of. And if you look through them, although there were decisions of the International Court, they all did not require the services of the International Panel of Experts because the judges, when I read the judgments, found that in all these cases, they had found that the governing law was in fact Chinese law. So there was no room for the international experts to be called on. So far, it's there in principle, but it hasn't really functioned as an international court, I think, quite yet.
So this is really interesting and related to something Mr. Justice Reyes said. I was also wondering what advice you had for lawyers appearing in front of you, either for local lawyers who are appearing in front of you as somebody who's mainly been trained in a similar but different legal system, and also for traveling lawyers who are themselves flying in.
Well, in the first case of the SICC, we had submissions, direct submissions in English by Indonesian lawyers or an Indonesian professor of law. So they made submissions to the court directly as if they were counsel appearing before the court. More recently, I've had a case where submissions were made in relation to DIFC law, the law of the Dubai International Financial Center. But that was made primarily, that was made essentially by written submissions, effectively by English lawyers who had knowledge of DIFC law. I actually think, on the basis of my experience, that it doesn't, there's nothing really special about appearing before a traveling judge. You behave as you do before any other judge. In other words, you are succinct and to the point. You identify the issues and you deal directly with the issues rather than going around the bush. I think that's most effective, whatever the judge that you appear before. There's no special magic just because you're appearing before a traveling judge. And that is the same whether you're a traveling lawyer, itinerant lawyer, or a domestic lawyer.
Let me share with you my experience in the DIFC courts. We had judges from England, Australia, New Zealand, Malaysia, Singapore. And I'm sure my fellow judges have the same experience, but when I would sit in the DIFC courts, I found that the lawyers were trying very hard to look up any case they could find from the Singapore law reports, which were pertinent to the point, if it's the common law point. And I know that they would have done the same thing with the English judges, and that would be the starting point, because essentially the DIFC laws, although they were laws written specifically for the DIFC, were based on English law, but with some civil law elements. So sometimes it was a bit tricky because, for example, our contract law does not make penalties illegal. We actually adopt the civil law system of allowing people to sue on contractual clauses, which actually are penalty clauses, but the court has the power to moderate the penalty. So leaving that aside, because that's actually a modification of the common law, from all the other common law judges sitting, every time a common law judge sat, the local bar would go and look up all the cases that they could from that particular jurisdiction and cite it to that local law. So the DIFC jurisprudence has become enriched with many, many citations from all parts of the Commonwealth. So obviously the advice is look at your judge and then submit your cases in a way that will appeal to him.
Yes, I think one of the issues in the smaller jurisdictions like the Cayman Islands is that if you're a local judge, certainly you expect traveling counsel to be aware of local law and local cases. And there are areas where you have local statutory idiosyncrasies. And there can be a tendency for a traveling lawyer to assume that the law is the same in the jurisdiction they're visiting as it is in the jurisdiction they've come from. And so equally, I think it's fair to say that the traveling judge has to be very much aware of the local landscape. And even if the legal culture is generally the same, the legal content will often be different in one or two areas.
It's very interesting. So we have more questions, of course, but I do want to give some of our participants the opportunity to submit their questions as well. And I also want to take this moment to allow those who are interested in CLE credit to be able to take advantage of that. So I believe that Heather will put up a slide. The slide will include the code that the attendees that you need to use to obtain CLE credit. And if Heather doesn't have it teed up, then I will have to, oh, there it is. There it is. There we go. Okay, so no problem. So this is the slide for the CLE credit. So I will read it out loud as did it go away?
Yes, it went away.
It went away. Oh, I think I was supposed to read it. So CLE credit for this session is available for New York and California. And attorneys licensed in other states can apply for CLE credit in their own jurisdictions using the New York CLE certificate. So I think I'm supposed to say out loud that the number is 427256. And if you need to request a certificate, you can fill out an affirmation form at apiarbitrationplace.com/ILA. So again, the CLE code is 427256. And I think that is the extent of our interruption. The CLE form is going to be available and should be completed by November 12th. So if you have any questions about that, you can follow up with us later, but hopefully that will allow everybody who is interested to get CLE credit. Now, with apologies for that interruption. I would encourage, I just wanted to take the moment also to encourage any attendees to submit questions through the Q&A function on the bottom of your screen. And as I don't see any questions up there yet, I'm going to proceed with my own questions because.
Can I just add something?
Yes. Oh, please. Yes, your questions are even more important.
Yeah. One of the interesting things about the DIFC course was we probably have the most generous admission requirements for any foreign lawyer to travel. We had a rule that said any foreign lawyer could have admission to the DIFC bar if they were admitted to the bar of any country in the world and was still in good standing. And second, he had a sufficient command of English to be able to conduct a hearing in an English-speaking court. And so we had a lot of civil lawyers appearing. Of course, there are a lot of English expatriate law firms in Dubai anyway. So they strengthened their offices when the DIFC courts opened, and a lot of their solicitors who might not have had the opportunity to argue heavy commercial cases back in England because of the separate bar, which didn't exist in Dubai, would then send their solicitors to argue. So you would have English trained lawyers who were trained both in English law and in English civil procedure. Now that second point was a very important advantage to English trained lawyers compared to common law lawyers from any other jurisdictions, as well as civil trained lawyers. But I've heard some very good arguments from civilian lawyers, civil law lawyers, if they were simply asked to argue a point of law or a point on appeal, where they didn't have to know the whiteboard backwards. Even an American lawyer who had worked for a lot of his professional life in London and thought he knew English law, when he came to Dubai to try and argue the case, and in the interlocutory stages, I could see that he was fumbling and not coming to grips with the white book, which is, the Bible for all civil procedure lawyers in running your case through a civil court. He knew the law and he knew the general idea, but the detail of the white book, which is over 1,000 pages, is a bit difficult for a beginner. So in the end, he went and found himself an English barrister who came and argued the case for him. And that is what a lot of the local lawyers used to do. But if they didn't have to grapple with the civil procedure side, they could actually argue quite well in a second language and not in a law that was their native law. That was the interesting experience that I had.
So we have a few questions in the chat. I'll start with a short one, and then Alyssa can pose the longer one. The first is, I believe it's from Caroline. She asks, do you hire law clerks? And if so, how might one apply? The reference in the chat to Oscar is a reference to the system through which you can apply to clerk for a U.S. federal judge. I'm assuming that you don't use Oscar, but I'm interested very much in whether you hire law clerks and your approach to that.
The Singapore court has JLCs, judicial law clerks, and that there is a procedure for that. Typically, these are the top law students from Singapore law schools, or Singaporeans who have gone and studied law in other universities such as Oxford or Cambridge. So it would not be easy for someone to become a judicial law clerk unless you're already within the system. However, you can apply to be an intern at the SICC, and a number of students have. And I would suggest, if you wish to apply, you simply write to the SICC, the Singapore International Commercial Court, and can say that you're interested in becoming an intern, and present whatever documents you think would be appropriate in order to make your application attractive.
Yes, we don't have in the Cayman Islands, or indeed in Bermuda, a system of clerks. It's something that always sounds very exotic to me, and sort of luxurious, the idea that one would actually have help with doing research. And so there is really no formal avenue to do clerking or internships. But having said that, it's always possible, if someone were to write to the Chief Justice and make an inquiry about doing an internship, that some sort of ad hoc arrangement could be worked out, and it might indeed lead to some more formal structure. It's, in a sense, surprising that we haven't actually got more formal internship arrangements in place, because I think the work that we do in our respective jurisdictions is something of interest to law students and young lawyers.
If Judge Kawale is finished, just to complete the picture, DIFC courts has a relatively small budget, and it does take interns. Law clerks are a slightly different thing. What the DIFC courts have are judicial officers, and they are full-time jobs. And they're usually for people with a little bit of experience somewhere else, and they come in at an appropriate level to their experience and what they can contribute. Because it's a small court, you kind of have you have to multitask. And so it depends on what areas you have experience in, or what you have an interest in, and whether those fit the needs of the DIFC courts at that particular time.
Right, so we are lucky to have in our audience Professor Matthew Erie, who's himself an expert in international commercial courts, and he asks, are traveling judges meaningful actors in creating private international law? And if so, how? And then there's a second question, but I'll ask this one first. It's a bigger question, one I've wanted to ask.
Insofar as creating or developing private international law, I'm not so sure. If you look at the three traditional areas of private international law: recognition and enforcement of judgments, jurisdiction, questions of jurisdiction where a case has foreign elements, and then choice of law. Recognition and enforcement of judgments, I'm not sure that the International Commercial Court has much say on that. It'll be for other jurisdictions to decide whether or not to recognize our judgments. In terms of establishing jurisdiction, the SICC has basically one ground for establishing jurisdiction. That is, the parties have designated the SICC as the court to determine disputes arising out of their international commercial contract. And that the SICC would have jurisdiction even if the parties have no other connection with Singapore apart from the choice of court agreement. So I'm not quite sure that there's much scope there for developing private international law in terms of jurisdiction. In the third area, choice of law, there may be some scope, but presumably in most choice of law questions, the SICC as a division of the Singapore court would be applying the choice of law rules of Singapore. So I'm not sure to what degree it would lead to a unification or harmonization of private international law principles across borders. The final area, the more modern area of where private international law is concerned, one that is intimately related to the Hague Conference, is the harmonization or the gradual harmonization of cross-border law across jurisdictions. Perhaps that's a more meaty area, but private international law being to some extent adjectival, on the side, ancillary to substantive law. I think that the SICC or other international commercial courts have a better prospect in developing the law, substantive law, and articulating the lex mercatoria or transnational commercial law principles, not so much private international law, I'm afraid. For private international law, I think one has to rely more on institutions such as the Hague Conference.
The Hague Conference reminds me that when the Hague Convention on Choice of Courts came out, my courts were very eager to sign up for this. And we looked closely at the convention, and of course, convention says the courts of a country, and it has to be the state courts as a whole. So we discussed it, I think, with the Hague officials, and they said, well, you might be able to come in if the UAE allows a carve-out for you to apply on your own. And we went back and discussed it, and it was told to us that national policy of the UAE was that they were not ready yet to consider acceding to the Hague Convention. So, and they didn't want us to go off on our own. I believe I had a conversation, Anselmo, with you about that time when you were representing the Hague Conference, and you shared with me, I think, that there was a similar kind of situation with the Hong Kong courts being part of China, and you can elaborate on that. But from the pure private international law point of view, we had two issues. The first is in the field of enforcement of judgments that Anselmo had discussed. And it's a little bit, our problem is unique because, as I said, one country, two systems, meaning two legal systems. So when we enacted our arbitration law, we adopted the model law. And in the model law, it says that you will recognize all foreign arbitrations and enforce them unless, among other things, they violate the public policy. And the model law says of the enforcing state. Now, what do you mean by the enforcing state? In the first version of the DIFC laws on arbitration, the public policy stated in our original law was the public policy of the DIFC on the grounds that we were a separate legal creature with its own internal laws. So the public policy concern was our public policy. Paradoxically, when a few years later, the UAE acceded to the New York Convention, which is, of course, the flip side of the model law, our arbitration law was changed by the legal experts in the UAE, and that public policy requirement was then changed to the public policy of the UAE. Now, the public policy of the UAE is a civil law concept, as opposed to the public policy of the DIFC, which is a common law concept. And those of you who have done international arbitration will be familiar that there are differences of the scope of how widely you interpret the phrase public policy in the context of enforcement.
Mhm.
And the experience of people who have awards and go and enforce them in the Dubai national courts is quite different from people who would try and enforce similar awards in common law courts. So there's a tension there. Even though now the national arbitration law of the UAE has been changed to conform with the model law. The second issue of private international law, which is problematical, again, arises from this concept of a state within a state. We're not a state, of course, but that's the analogy. And the original drafting was to make it very clear that the issue of the jurisdiction of the DIFC courts was to be determined by the DIFC courts itself. So it's a carve out of the jurisdiction of the whole of the Dubai courts, which itself is a carve out of the jurisdiction of the courts of the UAE. So there's a carve out within a carve out. And then, but people wanted to forum shop, and people who didn't want to be dragged into the DIFC, even though our legislation captured the case, would then go and file a counter summons or writ in the Dubai courts. And then there was this issue of which court will prevail. And so what happened was, because of all these disputes, and there were conflicting judgments from the DIFC courts and the Dubai courts, there was a national law passed to set up a judicial institute which would determine all these conflicts of jurisdiction. And I served on that committee for a few years before I stepped down, and we didn't always agree. And I'll just leave it at that. So there are issues which arise from internal conflict of laws, which is a form of private international law.
Yes, I would agree with Anselmo that I think the main private international law issues that arise tend to be somewhat peripheral, but I think in an international court setting, you do get perhaps more private international law issues relating to enforcement of judgments and jurisdiction than you might get in a more insular jurisdiction. And so traveling judges have the opportunity to be involved in making decisions about these issues. One particular area, I think, that has developed more in a jurisdiction like Bermuda is the common law principles relating to the recognition of foreign insolvency proceedings. And that is because there hasn't been that much statutory development of international cooperation in insolvency matters, because the focus of law reform has tended to be on creating structures that will encourage people to set up businesses in the jurisdiction, rather than setting up structures that will allow creditors to get relief. And so I think the judges have been much more active in jurisdictions where you don't have developed statutory and insolvency law or international insolvency provisions, in creating law to be able to give effective relief to international creditors.
That was also a big problem for Dubai, because when the DIFC was started, it introduced quite a sophisticated insolvency law based on the then current UK insolvency legislation. So you would think that it was quite modern and up to date. And I have to say that in the whole of UAE law at that time, the law of bankruptcy, both personal and corporate, was quite underdeveloped.
Mm-hmm.
Then we had a crisis in 2008, which was just after the Lehman Brothers crash. One of the largest companies in Dubai was on the verge of bankruptcy. And it was so serious, and it was such a large company, that the DIFC court judges were called back, or I was called back together with Sir Anthony Evans. And the problem was that there was certainly no legislation under national Dubai insolvency law that could deal with a Chapter 11 situation. And that was what was needed, a workout to save this company, which was a very, very important part of the Dubai economy, called Dubai World. So they had to create a special law. So we said, look, what's wrong with using the DIFC law, which is up to date? But those are drafted by English lawyers. And the government was being advised by American insolvency lawyers. And American insolvency lawyers just love their Chapter 11. You don't have a Chapter 11 as such. So they rewrote a special law for one company only. And it's called the Dubai World Tribunal Order. And that imposed a freeze on all claims against Dubai World, which is such a large company, it had 1,000 subsidiaries. And the first thing that, serving as a member of the tribunal, I asked for was, let's have a list of his subsidiaries. He said, that'll take a while to gather. It was not exactly that well run in that sense. And that tribunal still exists because it's taken a long time to solve it, but it actually saved that company. And so a fairly sophisticated insolvency regime was established by ad hoc legislation. And you can do that in a new, and you can do that in a country where legislation is enacted very fast. That's one of the advantages of not having a parliamentary democracy, let's say, that legislation can get through on an emergency basis pretty quickly.
Very interesting. That's as perhaps a segue to what may be our last question. Thank you so much. So this was submitted by Atossa Abrahamian. Do traveling judges as individuals or as a profession ever face political opposition from, she says, from populist or nationalist parties or movements? But I think you sort of hinted already at the sort of potential conflicts with the local government. So I leave that question for you. Is there ever any conflict or opposition?
Yes, I mean, if the question is directed at sort of the work of judges in the commercial domain, I would say I can't think of any conflict at all. Any conflict would tend to arise in the realm of public law, dealing with issues that had more impact on ordinary people. But generally speaking, the international commercial disputes are quite detached from the local terrain, which is the space that is lived in by local people and politicians.
I'm not sure if the opposition is to traveling judges. I've always felt welcome in Singapore, and I'm grateful for the warmth with which I've been received there. But there may be opposition to the notion of an international commercial court. In France, for instance, I understand there's a debate whether international commercial courts are simply justice for the rich. If you can afford it, you can go to the International Commercial Court, just like you can go to the fast queue lane at the airport. On the other hand, if you've just traveled economy class, if you don't have the means, then you queue up with everyone else for the regular courts, which might be congested and might take time. I think that perception of international commercial courts is incorrect. I think that international commercial courts are working very hard to improve access to justice, not just for big multinational companies, but also for micro, small, medium enterprises. And a recent example is in the SICC, where the SICC, where Singapore has allowed third-party funding for cases before the SICC as opposed to other Singapore courts. So hopefully measures like this to allow third-party funding for claimants before the SICC will enable MSMEs to take advantage and and remove this perception, which I think is erroneous, that international commercial courts are simply for the rich.
Yes, perhaps I could just add, I think I may have misunderstood the question slightly, that in the Cayman Islands, for example, the financial services division is very much a part of the main court structure. And so the judges are occupying the same physical space as other judges. And there isn't as strong a separation as there might be in those jurisdictions that have literally freestanding commercial courts. And so the possibility for that tension doesn't really arise. The other thing I would say is that I've always believed that there are spillover benefits from having international commercial judges for the other areas of the law, because it's very difficult to maintain a sort of very modern internationalist approach, wearing one hat as a commercial judge and then do something completely different wearing another hat. But that is because in jurisdictions like the Cayman Islands, you may be dealing with a commercial matter one day, you might also be dealing with a public law matter the other day.
It also depends on what you mean by commercial. In the DIFC, when we started, the cases coming in were quite small, and we were mainly serving the needs of the people who were actually operating out of the DIFC. And of course, in its early days, the number of companies were relatively small, and the number of transactions they had were relatively few, and it took a while before they actually had disputes which needed to be litigated. So the early cases that we were getting were actually cases of employment disputes. The highest number of cases that we had were employment cases. And technically, depending on which jurisdiction you come from, some people would say that employment cases are not commercial. And this actually had a slight complication because the division of responsibility between what we did and what the national courts did was that we were supposed to do commercial cases. But in the early days, we were doing so many employment cases. That was our bread and butter for quite a while. And after a while, it continues to have quite a strong numerical effect, impact on our statistics. But what happens is, of course, the value of those claims were relatively low. And my predecessor quickly decided that because we only had one level of courts in the DIFC courts, we didn't have a lower court like a district court or a county court or the equivalent, of a small court. We then copied legislation from Singapore, where we have a small courts tribunal, where lawyers are not allowed, and people come and are represent themselves, and they are obliged to go through compulsory mediation first. And if the mediation doesn't succeed, then they go to another judge who will then hear the dispute in accordance with legal principles. And so at some stage, somebody said, "Are you sure that this is commercial?" And it's eventually been accepted as such. But when you say, is commercial, does it include things like employment? Certainly in the financial crisis, in terms of monetary value, yes, because all of the companies were sacking their CEOs, and the CEOs were certainly not at the same level as the average laborer who was being thrown out, and his visa his passport was being held by his employers, and those are the kind of disputes that we had to deal with, as opposed to a guy who was on a 10-year contract and had been terminated earlier and wanted 2 years compensation. That kind of a case is definitely commercial. So perhaps it's only a question of the quantum.
All right. Well, I'm sure there's a lot more to say, but we are at the end of our time. So I'd like to thank everybody for coming today. Thank you very much to our panelists for taking the time to educate us about their courts and their work. And thank you very much to the attendees for coming, whether it's early or late where you are, and for asking your questions.
Thank you so much. This has been a terrific conversation.
Thank you very much.
Thank you.
Yes, thank you. Thank you for having us.